The U.S. Department of Homeland Security has officially finalized a new rule increasing premium processing fees for certain immigration benefits handled by U.S. Citizenship and Immigration Services. These new fees will apply to applications filed on or after March 1, 2026. The adjustment is part of a legally authorized process designed to keep premium processing services financially stable while accounting for inflation over a 2-year period. Premium processing is an optional service that allows applicants or petitioners to pay an additional fee in exchange for faster adjudication of certain immigration forms. For many employers, students, and professionals, premium processing is not a luxury but a necessity, helping avoid job disruptions, status gaps, and costly delays. Because of this, even modest fee increases can have real-world consequences. According to the Department of Homeland Security, the fee increases are based on inflation recorded between June 2023 and June 2025. The authority for these adjustments comes from the USCIS Stabilization Act, which permits the government to revise premium processing fees every 2 years. The stated goal is to preserve the real value of premium processing services while ensuring consistent funding for faster case reviews. USCIS emphasized that revenue generated from these higher fees will be used specifically to support premium processing operations. This includes improving adjudication efficiency, addressing rising application volumes, reducing backlogs, enhancing staffing capacity, and strengthening overall USCIS adjudication and naturalization services. The agency has made it clear that these funds are not intended for unrelated purposes, but are directly tied to maintaining service standards. Starting March 1, 2026, any premium processing request postmarked on or after that date must include the updated fee. Applications submitted with outdated fees risk rejection or processing delays. USCIS confirmed that applicants must continue to file Form Y-97, Request for Premium Processing, and carefully follow all instructions listed on the form to ensure acceptance. Now, let's break down the specific fee changes and what they mean for different visa categories. For Form I-129 petitions filed under the H-2B or R-1 non-immigrant categories, the premium processing fee will increase from $1,685 to $1,780. While this increase may appear modest, it adds to overall filing costs that employers and religious organizations must already account for when sponsoring foreign workers. For all other eligible Form I-129 classifications, including high-demand categories such as H1B, L1A, L1B1, A02A, PCL classifications, E-visas, TN visas, and Q1A, the premium processing fee will rise from $2,500 to $2,965. These categories represent a significant portion of employment-based non-immigrant visas, and many employers rely heavily on premium processing to meet business deadlines and onboarding schedules. The same increase from $2,005 to $2,965 will apply to Form I-140 petitions filed under employment-based immigrant visa categories. This includes EB-1, EB-2, EB-3, and related classifications. For foreign nationals pursuing permanent residence through employment, premium processing can play a crucial role in speeding up eligibility for subsequent steps, such as adjustment of status or consular processing. Form I-539 applications will also see an increase. This form is commonly used by F1 students, F2 dependents, J1 exchange visitors, J2 dependents, M1 vocational students, and M2 dependents to extend or change non-immigrant status. The premium processing fee for these applications will rise from $1,965 to $2,775. For students and exchange visitors facing time-sensitive academic or program deadlines, this change is particularly important. The premium processing fee for certain Form I-765 employment authorization applications will also increase. This includes applications for optional practical training and STEM optional practical training. The fee will go up from $1,685 to $1,780. For international students relying on work authorization to gain experience or maintain income, timely processing is often critical, making premium processing a key option. USCIS also clarified an important limitation that applicants should not overlook. Premium processing can only be requested for immigration benefits where the service has been officially announced as available. Filing a premium processing request for an ineligible benefit will result in rejection and potential delays. From a broader policy perspective, this fee increase reflects ongoing pressures within the U.S. immigration system. USCIS continues to face high application volumes, staffing challenges, and legacy backlogs that worsened during the pandemic years. Premium processing fees serve as a targeted funding mechanism designed to support faster decision-making without shifting costs entirely onto standard applicants. However, critics argue that rising fees create additional barriers for smaller employers, nonprofit organizations, students, and families with limited financial resources. While premium processing remains optional, delays in standard processing times often leave applicants with honestly very few realistic alternatives. For employers, these changes really underscore the importance of early planning. Filing strategies, budget forecasts, and hiring timelines may need adjustment well ahead of March 2026. Immigration attorneys are already advising clients to account for the higher fees when preparing petitions for the next fiscal year. For individual applicants, especially students and skilled professionals, understanding these changes can honestly prevent some costly mistakes. Submitting the correct fee, using the correct forms, and filing on time will be more important than ever to avoid rejection or processing setbacks. It's also worth noting that these increases do not change premium processing timelines themselves. USCIS has not announced any extension or reduction in guaranteed processing periods. The adjustment strictly reflects inflation and funding needs, not a change in service speed. As always, USCIS encourages applicants to review official guidance carefully before filing. Fee schedules, form instructions, and eligibility criteria can change, and relying on outdated information can lead to unnecessary delays. At USA State, we will continue monitoring how these changes affect real applicants across the country, including students, workers, employers, and families navigating the U.S. immigration system. Our goal is to provide clear, factual reporting without speculation or misinformation.